number 20-2217, Liz Brady versus Wendy Lieberman. This is the plaintiff's amended verified motion for summary judgment for damages. Mr. Tadros, didn't you send me an agreed order?
I don't believe so, Your Honor. Double check.
Okay. I've signed a couple things this morning with your name on them, but maybe they were on other cases, but.
That might have been. We had some hearing, I think we had a hearing on Friday, so that might be
Okay.
residuals from that day.
All right. I saw a notice of cancellation on the Friday, and it says settlement reached.
Your Honor, Friday is like a lifetime ago. I would literally have to go to the plaintiff to see what happened.
Somebody had a deposition, and I saw a notice of cancellation, and it said in parentheses, settlement reached. And my heart got all fluttery, and...
I know we did recently settle one that we had a hearing on last week, and that might be the one you're referring to, so
all right,
we're trying.
An email on it. All right, so back to you, Mr. Dishowitz and Ms. Liederman. Mr. Dishowitz, this is your motion, your amended verified motion for judgment for damages. You may proceed.
As a procedural background, Your Honor, thank you, Your Honor. On October 1st, 2020, we filed a complaint for eviction and damages. On October 12th, the defendant filed her answer to the complaint. On October 22nd, the court entered a default final judgment on count one only for eviction. On October 27th, the defendant filed her notice to appeal. Just recently, April 29, 2021, the court PCA entered an order affirming the default final judgment for eviction and an order granting plaintiff's attorney's fees. The underlying facts are plaintiff was the owner of the real property. Defendant was in possession of the property. Pursuant to an oral agreement, plaintiff leased the property on a month-to-month basis for $725 a month. On July 20th, plaintiff served defendant with a notice letter notifying the defendant that it would terminate the lease at the end of the next term, August 31st, 2020. August 31st, 2020 came, the defendant failed to vacate. She stayed until Monday, November 16th, 2020, when she was evicted. During that time, she was deemed a holdover tenant pursuant to 83.58. Therefore, the defendant owes plaintiff $3,623.01, as double the amount of rent from September 30th to November 16th. Pursuant to defendant's own admissions in her answer, which I provided, she admitted to owing plaintiff $2,405 in unpaid overdue rent at that point. Therefore, the total amount of undisputed unpaid rent is $6,028.01. Plaintiff was required to retain the services of an attorney, obviously, for which defendant must not pay those fees pursuant to 8348 and the court PCA's order approving same. I filed a motion for attorney's fees, which amounted to, with fees and costs, $22,131.83. So that with the principal amount due, we're seeking $28,159.84. Thank you, Your Honor.
Thank you, Mr. Dishowitz. Response?
That was my motion.
Right. I said thank you, Mr. Dishowitz.
Oh, I'm sorry.
So
I'm going to ask you for a response. Yeah.
No, it's okay. Response? I should have had a longer pause. I apologize. Ms. Liederman?
Yes.
You filed an objection, so outline your reasoning for your objection to the motion.
Well, first, this is the code enforcement violation that was on September 30th for an inoperable toilet of 8 days and hot water that I didn't have for months. I started, it was June 30th was the first time I notified of the no hot water. I notified that I was going to withhold rent properly according to 83.51B on July 17th. And then July 24th, all the tenants in the building got a defective threat for vacancy. They all still live there. There was no date, and it was handed to everybody. There was never a formal notice, but it was retaliatory anyway because I had lacking services. My AC went, my stove went, and these are all violations of 83.561B. When I asked for proof of debt for the claim ledgers, they mismatched each other as attached to the objection and several other pieces of evidence, but there were different claim ledgers. And then there's actually an admission by the plaintiff, submitted accidentally, I guess, by the counsel, that says we will go by this even if I screwed up, where she's talking about a false amount of money, a fraudulent amount of money that she claimed prior to any of this. This was in June. And then the motion to determine rent was actually retitled to a motion to dismiss, which was really odd. So I didn't actually get determination for CDC or for rent determination. The case was closed a day early. I was denied bond, and even my motion for rehearing was sent back to me from the 4th District in another envelope that I actually sent it in, and they claim they never got it. And the supplement to the record, they denied with the decision after I wrote my brief 5 months after I submitted supplements, which I think goes against 9.200F12, which says there's no final decisions based on an incomplete record. But just this code enforcement violation for an inoperable toilet violates 386.041, which is punishable by 386.051. It's a second-degree misdemeanor, which is 6 months in jail. And I'm being sued when all I did was complain for uninhabitable facilities. So I believe that under 83.561B, I should have been determined rent that was in proportion to the reduced services that I was provided. And again, the defective notice that all the tenants received on July 24th had no date on it, it had no notice, and it came after 7 days after my notice to withhold, proper notice to withhold, which is also included in the evidence. And yeah, this is a completely unlawful eviction. And I should actually be owed money under the prohibited practices of 83.676.
All right, thank you, Ms. Lieberman. Brief response, Mr. Deschwitz?
Yes, Your Honor, no counterclaim was filed in this matter, therefore her damages don't actually mean anything at this point.
Statutory.
Entertained at the original underlying eviction hearing. Also, it was also taken care of during the appeal. So none of this stuff actually matters at this point. We saw
My constitutional right to determination does matter.
Saw the complaint way more than $2,405. We've reduced it to what she's agreed to or what she's admitted to. It states in
That's
her
untrue.
answers, I owe $2,405. That's the number I took, plus the time she spent as a holdover tenant. That's how we came to our determination of principle. The attorney's fees speak for themselves. I had to, endure an appeal on this, and we're not asking for all of our damages. We're asking only for what she's admitted to. Thank you, Your Honor.
Did you want to say something, Ms. Lieberman? I heard you talking.
I mean, I object to everything he just said. I mean, the eviction came 1 day after the city came to fix my toilet that was left for a week. That's a sanitary nuisance injurious to health. That's a misdemeanor. And the conflicting ledgers of the false debt claims that I was served, I mean, she lives in another state. She lives in Covington, Georgia. This is a felony. I mean, I'm entitled to determination of rent. Even without a counter, which this all happens so quickly, statutory law says that I'm entitled to 3 months rent for every violation that is against prohibited practices. I had no toilet for a week and no hot water during the pandemic. Like, this is insane. And I did everything proper. I gave proper notice. The damage claims are absolutely erroneous.